Good evening, class. Tonight we will be talking about Title 13 of the Revised Corporation Code of the Philippines. Tonight's topic will be Special Corporations. Now remember, our source materials are still the same: Partnerships and Private Corporations by De Leon and De Leon, and also the Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So Title 13 is comprised of 3 chapters. We will begin with the first one. Chapter 1 talks about educational corporations. So educational corporations are defined as stock or non-stock corporations which provide facilities for teaching and instruction. So remember, because they provide teaching and instruction, so in short, they provide learning. Now, to provide learning, remember, the educational corporation must maintain a regular faculty. It must have a regular curriculum, and normally it will also have a regular organized body of pupils or students. Ngayon, itong mga pupils or students niya, obviously they have to go to a certain attend at a certain place where the educational activities are regularly carried on. Kailangan merong school. So remember, ito ang definition ng isang educational corporation. So the laws applicable, what you have to remember is that educational corporations are classified as special corporations by the revised code. These are different from ordinary non-stock corporations for educational purposes. Magkaiba daw sila according to the revised code. Now also, educational corporations are governed primarily by special laws and suppletorily by the general provisions of the revised corporation code. Now, if your educational corporation is a stock corporation, it is governed by the provisions on stock corporations as to number and term of directors. What else? Please take note of some rules for board of trustees or directors in educational corporations. So for non-stock educational corporations, trustees shall not be less than 5 nor more than 15. It shall be in 15. Dami naman. They shall be in multiples of 5, meaning the number should be 5, 10, or 15. So obviously, hindi pwedeng 8, hindi pwedeng 9. Kahit na favorite number yung 7, anniversary nyo ng inyong boyfriend. Wala akong pakialam. Pagdating sa educational corporation, remember, it should be only 5, 10, or 15. Hindi pwedeng iba. What else? Unless otherwise provided in the articles of incorporation or the bylaws, remember, term of office of the first elected trustee shall be staggered with 1 year interval. So, kailangan yung first elected staggered with 1 year interval sila. Iba-iba sila ng term, yung first elected trustees. So, bawat isa sa kanila, iba yung term. And remember also, they must so classify themselves that the term of office of 1/5 of their number shall expire every year. So kung 10 ang iyong trustee, 1/5 of their number or dalawa, yung bawat taon, yung term ng dalawa sa kanila ay mag-expire. So anyway, we will illustrate later on kung ano yung staggered term of office ng trustee sa isang non-stock educational corporation. Trustees subsequently elected, yung mga susunod na dun sa first elected trustees, will have a term of 5 years. Now also, please take note that trustees, replacement trustees will hold office only for the unexpired portion. So if it is 5 years, remember the term is 5 years. If one serves for 3 years, yung replacement will serve for the remaining portion of 2 years. What else? Majority trustees will constitute a quorum for the transaction of business. Remember, for the transaction of ordinary business, majority of the quorum. But remember also that there are rules provided for, as we have already discussed before, wherein kailangan ng majority of the total number of trustees para i-approve ang isang corporate action. What else? Powers and authority of the trustees shall be defined in the bylaws, obviously, and subject to the provisions of Section 22, meaning your board must act as a body. For stock educational corporations, number and term of directors shall be governed by the provisions on stock corporations, like I have said a while ago. Now, this is the illustration of the staggered term of office. So, medyo nakalatag na siya. But anyway, I will explain using this pointer, as you can see. So anyway, this is a non-stock educational this is a non-stock educational corporation, under a special corporation under Title 13 of the Revised Corporation Code of the Philippines. Meron siyang 10 trustees. So, remember, the trustees so elected. Ito na yung mga elect: A, B, C, D, E, F, G, H, I, N, J. So, remember yung rule. Yung first trustees elected should classify themselves that 1/5 of the term of office of 1/5 of their number expires every year. So, yung mga first elected, kailangan nilang ayusin yung sarili nila para yung term ng office ng 1/5 sa kanila mag-expire every year. So here, 1/5 is 2 trustees. So let us say, ang napag-usapan nila is yung pinaka-konti ang boto, yun ang pinaka-konti ang term na is-serve. So let us say A and B, they receive the lowest number of votes, pero panalo sila. And I and J, they receive the highest number of votes. Sabi, staggered ang kanilang term. So remember, staggered with 1 year interval. So magkakaiba na may difference na 1 year. A and B will serve for 1 year. C and D will serve for 2 years. E and F will serve for 3 years. G and H will serve for 4 years. And I and J will serve for yung full term na 5 years. Now, yung mga obviously, staggered na to kasi nga iba-iba yung term nila. May 1 year interval. So, if A and B will serve only for 1 year, remember their term of office will expire on 2021. Let us say 2021 election, ang nanalo si 1 and 2. Anyway, kina-next yearan, 2022, magbabakante na naman ang 2 seats. Matatapos ang term ni C and D. So ngayon, kung natapos ang term ni C and D, remember, bigla na-elect is A and B. 2023, again, natapos ang term ni E and F. Tapos, nag-elect uli ng 2. Remember, 1/5 ng number nila every year, nag-expire yung term. So, F and C, yung bagong na-elect. 2024, yung term ni G and H na 4 years, it expired. So, inelect si E and H. And lastly, 2025, nag-expire yung 5-year term ni I and J. So, nagkaroon na naman ng election for trustees and I and J na naman ang nanalo. Now, with respect to 1 and 2, remember, yung kanilang term of office, because they are not the first elected. Pangalawang na to pangalawang, kumbaga, hindi na sila yung unang na-elect. Kasi, di ba, unang na-elect yung set ni A to J. Ngayon, itong si 1 and 2, they are not first elected. Remember, ang kanilang magiging term of office ay hindi na yung 1 year, but it will be 5 years. That's why the term of office of 1 and 2 will expire on 2026. Nakita nyo naman yung last na election, 2025, di ba? Next election, mag-expire yung term of office ni 1 and 2. So, nag-expire na yung term of office ni 1 and 2, na-elect si G and 2. Same is true with A and B. Remember, A and B will serve 5 years. Yan. As nakikita nyo naman, ang term of office din ni F and C, 2023 to 2028. 5 years na. Yung mga una lang, ang staggered 1 year interval. Tsaka iba-iba. Pero yung mga susunod, 5 years na lahat yan. And again, it is designed in such a way that the term of office of 1/5 of the number of the trustees will expire every year. Kaya every year, nag-e-elect tayo ng 2 trustee. So anyway, I hope na nalinawan kayo sa example na yan. Hindi ko na itutuloy yung table anyway. It's the same concept. So, what else? Chapter 2, your religious corporations. Ito yung pinaka-paborito kong topic talaga. Pagka ito ang topic, inaantok talaga ako. Alam ko naman boring yung law, pero pagka religious corporation, 10 times mas boring. So anyway, let's talk about alive corporations. So remember, alive corporations are composed entirely of spiritual persons. And remember, they are organized for the furtherance of religion, or for perpetuating the rights of the church, or for the administration of church or religious work or property. So, sino naman yung mga spiritual persons na tinutukoy sa isang alive corporation? So, remember, spiritual corporations are bishops, certain deans and prebendaries, all archdeacons, persons, and vicars, which are corporation souls, and abbots and monks, which may constitute corporations aggregate. So, remember, yun ang composition, spiritual persons, yun ang mga klase ng spiritual persons. Please take note also of the applicable provisions for religious corporations. What you have to remember is that, again, a religious corporation is a special corporation defined under the Revised Corporation Code, specifically under Special Corporations Title 13. Now, this is not the same as an ordinary non-stock corporation organized for religious purposes. Magkaiba daw na naman sila. Again, now, religious corporations are governed primarily by Title 13, sections 107 to 114 inclusive, and suppletorily by the general provisions of Title 11 on non-stock corporations. So, yun ang kailangan nyo munang tandaan. Now, primary provisions to look at is yung mga provisions ng Title 13. If wala tayong makita dyan na pwede nating magamit, suppletorily, the general provisions on non-stock corporations. Also, please take note that bylaws of a religious corporation must conform with the general provisions affecting corporation. If there is inconsistency between the bylaws and yung general provisions affecting corporations, it shall be resolved in favor of Title 11 and also Title 13. Ibig sabihin, kung merong conflict between bylaws and yung sa law, yung law will prevail, specifically Titles 11 and also Title 13 on Chapter 2 on religious corporations. Please take note also of the classes of alive. So, number 1, yung corporate, paboritong topic talaga ng mga estudyante ko to last year eh. Gusto talaga nila yung mga alive corporations. Yun nga ang tawag nila sa klase namin, especially in section B. Alive corporation, yun ang tawag nila sa class nila. May group picture pa kami nun eh. Tatandaan ko. That's my favorite class last year, yung class ni na Miss Tiki, etc. and friends. So anyway, corporation soul, remember, it consists of one member or corporator only, isa lang. So, and his successor. So, bishop, kung namatay yung bishop, yung successor niya will comprise yung corporation soul. So, persons who may form yung corporation soul, archbishop, bishop, priest, minister, rabbi, or other presiding officer, elder of a religious denomination, sect, or church. And again, yung corporation soul is incorporated for the purpose of administering and managing as trustee the affairs, property, and temporalities of such religious denomination, sect, or church. What else? Number 2, religious society naman is incorporated by an aggregate of persons. So, any religious organization, any religious society or religious order, any diocese, synod, or district organization of any religious organization, sect, or church may incorporate for the administration or management of its temporalities, affairs, and properties unless it is forbidden by the rules of yung specific religious society, religious order na yan or organization. So, what you have to remember about a religious society, it is essentially a religious organization which incorporates into a corporation, obviously. So, yun lamang ang mga religious society. Yun lang, pinadali ko na. So, please take note also of the rules regarding a corporation soul. In case of filing of the verified articles of incorporation, remember class, yung corporation soul, para maging corporation soul, chief, archbishop, etc. must file with the SEC yung verified articles of incorporation, which will set forth the matters mentioned in section 109. So anyway, we will discuss that later on. Although pwedeng dagdagan ng ibang provisions as long as they are not contrary to law. Yung in addition to the verified articles of incorporation, it should be accompanied also by a copy of the commission certificate of election or letter of appointment of such chief archbishop, etc., etc. So, bukod sa verified articles of incorporation, hindi lang siya basang articles, verified siya. It must be accompanied by yung a piece of evidence or yung proof ng authorization or appointment, election noong taong yon na siya ang appointed na archbishop, etc., etc., noong corporation sole. What else? Yun nga yung sinabi ko kanina, contents of the verified articles of incorporation. Number 1, yung person applying to become a corporation sole is the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of his religious denomination, sect, or church, and that he wants to become a corporation sole. What else? The rules, regulation, and discipline of his religious denomination, sect, are not inconsistent with his becoming a corporation sole, nor does it forbid it. So, kailangan niyang ilagay doon sa kanyang doon sa articles of incorporation niya na yung rules ng kanyang denomination, religious denomination does not prohibit yung pagiging isang corporation sole. So, yun ang kailangan yung tandaan. So, what else? As such chief archbishop, etc., he is charged with the administration of the temporalities, properties, yun, and the management of the affairs, estate, and properties of his religious denomination, sect, or church within his territorial jurisdiction. Also describe kung ano yung territorial jurisdiction. What else? Manner in which any vacancy occurring in the office is required to be filled according to the rules, regulations, discipline of the religious denomination. So, kailangan mag-submit siya ng verified articles of incorporation. Anong laman nun? Ako yung archbishop, etc., etc. Gusto ko maging corporation sole. Tapos number 2, yung aming church hindi bawal yung pag-incorporate. Yun yung number 2. Yun lang ang ibig sabihin nun. Number 3, ako yung in charge doon sa mga properties ng simbahan namin. Yun lang ang ibig sabihin yan. And also, remember, there must be a description of the territorial jurisdiction. In charge ako sa properties ng church namin sa ganitong lugar, etc., etc. Number 4, pagka namatay, paano papalitan itong chief archbishop na to, etc., etc. Yun ang kailangan. How to fill yung any vacancy. So, it can be any way na nag-vacant yung position. How it is filled must be indicated dun sa articles of incorporation. Place of principal office should be, dito kami. Ito yung aming lugar. So, the location must be within the Philippines. Now, remember, in section 110, pagka-file ng verified articles of incorporation, the religious the religious denomination will become a corporation sole. And remember, all temporalities, estate, and properties of the religious denomination, sect, or church will be administered by such chief archbishop and held by him as a corporation sole for the benefit of the religious denomination, sect, or church. So, pagka-file pa lang, remember, your religious denomination is already incorporated as a corporation sole. Remember, it does not require the approval by the SEC of the articles of incorporation. Pagka-file, corporation sole na yan, and lahat ng properties niya will be managed already by yung nag-apply na archbishop, etc., etc. What else? Obviously, because it has juridical personality, it can purchase, hold property, real and personal. It can also receive bequests or gifts for the church, charitable, benevolent, or educational purposes. Now, dahil meron siyang property, it is in the name of the corporation. Now, if it will sell the property, remember, there must be authority from the regional trial court where the property is located before magbenta or isang layong property. However, if there is a provision in the rules of the religious denomination, sect, or church kung paano nila i-dispose yung kanilang property, hindi na kailangan ng authorization from the regional trial court. So, kung meron naman silang rules to regulate the sale, mortgage, acquisition, etc. of real or personal property of the corporation sold, yung rules na yun ang magko-control. No need to seek for permission or authority from the courts. What else? Filling of vacancies, 112. So, pagka nagkaroon ng vacancy, so there will be a successor. The successor will become the corporation sole after yung successor files a notarized copy of their commission, certificate of election, or letter of appointment. Again, itong mga to, they are the same animals. Ito lang ang proof na siya na ang in fact head nung church na yon at siya ay duly appointed or duly elected. Now, in case wala pang kapalit doon sa wala pang successor yung dating archbishop etc. ng corporation soul, yung persons authorized by the rules of the denomination will administer the affairs of the corporation soul during the vacancy, and he will have all the powers and authority of corporation soul. So yung temporary, siya talaga muna ang bahala. So paano ina-appoint yung temporary based on the rules of the religious denomination. What else? A term of existence, perpetual. It is not required to state yung kanyang term of existence. So indefinite ang kanyang existence unless otherwise provided. Obviously, pwede rin namang i-dissolve ito in 113. Corporation soul may be dissolved by voluntarily filing with the SEC for approval a verified declaration of dissolution which will set forth matters required under section 113. Now, if the incorporation does not need the approval of the SEC, pagka-file ng articles, verified articles, incorporated na. Ganun lang. Ngayon, pagka magdi-dissolve, remember, it needs the approval of the SEC. So, after approval nung verified declaration of dissolution, the corporation soul will cease to carry on its operations except again for the purpose of winding up of affairs. So the contents of the verified declaration of dissolution, name ng corporation soul, reason for dissolution and also winding up, authorization for the dissolution, and number 4, names and addresses of the persons who will wind up the affairs of the corporation soul. How about religious societies? So religious societies are composed again of an aggregate number of persons. So these are the rules. In case of the articles of incorporation, kailangan din nilang mag-file ng verified articles of incorporation to the SEC, which will set forth the matters required under section 114. Again, the law does not require approval by the SEC nung articles of incorporation ng isang religious society. Now, matters to be set forth in the verified articles of incorporation of a religious society. Number 1, na yung religious order, diocese, synod, or district organization is a religious organization. So, in short, religious organization kami. Period. Number 2, at least 2/3 of its membership has given their written consent or have voted to incorporate at a duly convened meeting of the body. So, katulad nga ng sinabi ko sa inyo, ang religious society is essentially a religious organization which incorporates. Now, to incorporate, kailangan nila ng written consent or vote ng 2/3 ng kanilang membership. Magbotohan tayo, 2/3. Pagka nakuha nyo yung 2/3, pwede na kayong mag-incorporate as a religious society. But obviously, even before that, yung inyong organization, yung group ninyo is already a existing religious organization. What else? Number 3, yung incorporation is not forbidden by competent authority or by the rules and regulations or discipline of the religious denomination, sect, or church. So, hindi bawal, hindi pinagbabawal sa rules ng religious org na to na mag-incorporate as a religious society. What else? Number 4, yung religious organization desires to incorporate for the administration of its affairs, property, and estate. And number 5, very important, place of principal office of the corporation to be established within the and located within the Philippines. So again, take note that you have to include also yung names, nationalities, residences of the elected trustees, and or to serve for the first year and such other period as may be prescribed by the laws of the religious society or religious order. So remember, the board of trustees must not be less than 5 nor more than 15. Take note that registration is not mandatory. Kung gusto lang nila, anyway, basta nakuha nila yung required vote, pwede na silang register as a religious society. So maganda na rin yan so that meron silang legal personality to administer yung kanilang properties. What else? Only upon incorporation that a religious society can have a juridical personality, and it will be allowed to acquire properties in its own name. What else? Term of existence, again, perpetual, unless it is sooner dissolved or revoked in accordance with law. So that's it for Chapter 2, Religious Societies. So Chapter 3 talks about one-person corporations. So ito yung pinakabagong type ng corporation na pwedeng i-incorporate sa Philippines. But the concept of a one-person corporation is not something new. Ginaya lang natin yan. Siyempre, alam nyo naman, sa ibang countries, uso na kasi sa iba. Kaya tayo namang mga Pinoy, siyempre, kailangan din nating makiuso para nga naman mas madaling mag-business dito sa Philippines. Remember, again, one of the reasons why there is an amendment of the corporation code is, again, ease of doing business in the Philippines para nga naman mas madaling mag-business dito. So, nakigaya tayo sa concept ng isang one-person corporation. So, a one-person corporation is defined under Section 116 as a corporation with a single stockholder. Even if it is a corporation with only one stockholder, remember, yung personality ng nag-iisang stockholder na yan is separate and distinct from the personality of the one-person corporation. Please take note of the applicable provisions under Section 115. Since your one-person corporation is classified as a special corporation, it is governed primarily by the provisions of Title 13 of the Revised Corporation Code of the Philippines, suppletorily by applicable provisions on stock corporations. Because remember, a one-person corporation is essentially a stock corporation, except na iisa nga lang kasi ang kanyang stockholder. Kaya binigyan siya ng sarili niyang title, binigyan siya ng chapter, binigyan siya ng sarili niyang discussion. So anyway, please take note also of persons who may form a one-person corporation, only a natural person, trust, or an estate may form a one-person corporation. And also, in case of natural persons, the incorporator, the sole stockholder, must be of legal age. Persons who cannot form a one-person corporations, syempre, banks, quasi-banks, pre-need, trust, insurance, public and publicly owned companies, non-chartered, government-owned and government-controlled corporations cannot form a one-person corporation. In case of exercise of a profession, remember, natural person who is licensed to exercise a profession may not organize a one-person corporation, subject to exceptions provided by special laws. What else? Capital stock in a one-person corporation, like in a regular stock corporation, it is not required to have a minimum authorized capital stock unless otherwise provided by special laws. Now, articles of incorporation of a one-person corporation, in addition to all the items listed in sections 13 and 14 of the revised corporation code, in addition to that, dadagdag pa to. Additional matters contained in the articles under section 118, if it is a single stockholder, if the single stockholder pala is a trustee or an estate, kailangan ilagay din yung name, nationality, and residence of the trustee, administrator, executor, guardian, conservator, custodian, or other person exercising fiduciary duties, together with proof of the authority to act on behalf of the trust or estate. So, ilagay dyan kung sino ang magmamanage nung trust or nung estate. So, sino ba yon? Yung trustee, administrator, executor, etc., etc. And also, there must be present proof of the authority given to such trust person to become the trustee, administrator, executor, guardian, etc., etc. What else? Number 2, name, nationality, and residence of the nominee and alternate nominee, and the extent, coverage, and limitation of such authority. So anyway, we will discuss more about nominees and alternate nominees later on. Bylaws are not required for one-person corporation. Kasi nga, bylaws are internal rules. Mag-isa lang siya. Ano pang rule ang kailangan niya? Mag-isa na nga lang siya. So, kung class, wala kayong friends, pwede na lang kayong gumawa ng one-person corporation. So, you do not have to deal with others. Lahat na lang ng katransaction mo, lahat ng kausap mo, empleyado mo na lang para hindi ka na rin mahirapang makisama. So, anyway, corporate name, in addition to yung name na gusto mo, you must also indicate yung pagiging one-person corporation by including the letters OPC either below. So, halimbawa, ito yung pangalan ng corporation mo, ilalagay mo sa baba, OPC. Yan, lagay mo sa baba. Halimbawa, Sheratiki, o kaya Eileen Hoson, estate, ganyan. Estate na agad, no? OPC, lagay mo sa baba. So, yun ang corporate name ng isang one-person corporation. What else? Single stockholder can use his or her name, katulad ng ginawa ko kanina, provided it shall be accompanied by descriptive words aside from OPC. Kaya nga sabi ko, Eileen Hoson Estate, yan, Estate of Eileen Hoson, estate talaga, no? Plus OPC sa baba. Kung ayaw nyo sa baba, sa tabi. Estate of Eileen Hoson, OPC sa tabi. Ang hirap mag-imagine, ano? So anyway, a single stockholder can also use the name of another person. Ang pangalan ng single stockholder na to is Eileen Hoson. Pwede niyang gamitin yung pangalan ng friend niya. Shena, Pineda, ganyan, etc., etc. Pwede niyang gamitin yung pangalan ng another person. And pwede nga rin niyang gamitin yung pangalan ng patay, provided that the estate of the deceased consents. So, if alive yung person, other person, obviously, kailangan ng consent niya. And again, it must be accompanied by descriptive words other than the suffix OPC. So, we referred to, again, SEC Memorandum Circular Number 13, Series of 2019, Amended Guidelines and Procedures on the Use of Corporate and Partnership Names. Also, please take note of directors and officers of an OPC. Siyempre, director and president niya, obviously, will be the single stockholder. So, wala naman, mag-isa kasi siya So, siya lahat. Pero pwede naman siyang kumuha ng mga ibang tao as employees. So, other officers may be appointed or appointed 15 days from the issuance of a certificate of incorporation. OPC shall appoint a treasurer, corporate secretary, and other officers as it may deem necessary. And after appointing such officers, ang importante lang talaga yung secretary and treasurer. Yung other officers pwede, pero syempre, ang nire-require talaga ng law is to appoint a treasurer and secretary and notify the SEC within 5 days from such appointment. In case of treasurers, these are the rules. rules, single stockholder may be also self-appointed treasurer. Wala kang friends eh. Hindi ako na rin ang treasurer. Sabi niya ganun. Pwede yun. Now, if you are a self-appointed treasurer and you are also the sole stockholder, you must file a bond with the SEC as in such sum as the SEC may require, renewable every 2 years or as often as may be required. What else? Also, the self-appointed treasurer / sole stockholder na wala talagang kahit na sinong kaibigan shall also make a written undertaking to faithfully administer the OPC's funds which he will receive in his capacity as treasurer and to disburse and invest the same in accordance with the purpose of the corporation and in accordance with the articles of incorporation. Now also, ito, you have to remember this. Single stockholder cannot be appointed as corporate secretary. Bakit? Because remember class, special functions of the corporate secretary as provided for under section 25 and also later on we will know section 123 will prohibit the appointment by the single stockholder as a corporate secretary. So bawal. Number 3, in addition to the special functions provided by law, OPC can designate other functions to the corporate dagdagan pa natin ang trabaho ng corporate secretary. So the special functions of the corporate secretary, which will be the reason why hindi pwedeng yung sole stockholder mo is yung corporate secretary. Yung corporate secretary will maintain yung minutes book and or records of the corporation. Number 2, ito na, dito mo nalaman kung bakit. In case of death of the sole stockholder, the corporate secretary must notify the nominee or alternate nominee of the death or incapacity of such sole stockholder. The notice must be given no less later than 5 days from the death or incapacity pala of the sole stockholder. So if it is the sole stockholder who is also the secretary, namatay siya, by law, wala, sino ang magno-notify? Because remember, the only person tasked to notify is yung corporate secretary. Wala naman kasing ibang stockholder yan eh, para siya ang magno-notify dun sa nominee and or alternate nominee. So what else? Notified the SEC of the death of the single stockholder within 5 days from such occurrence and stating in such notice names, residence address, and contact details of all known legal heirs. What else? Call the nominee or alternate nominee and the legal heirs to a meeting and advise the legal heirs with regard to the election of a new director, amendment of the articles, or any other consequential matters. So, yung corporate secretary upon the death of the sole stockholder must bring together yung nominee or alternate nominee and also the legal heirs, yung mga naiwan niyang mga tagapagmana para malaman nila kung ano ang gagawin nila with respect to the one-person corporation. Nominee in case of death or incapacity of a single stockholder is covered under section 124. So remember, the nominee and alternate nominee shall be designated by the single stockholder. And remember, in the event of the death of the single stockholder or incapacitated pa lang naman, di pa naman patay, pwede na. Kailangan na rin ng nominee. The nominee or alternate nominee will take the place of the single stockholder as director and shall manage the affairs of the OPC. Siya nang bahala, siyang in charge. So, obviously, your single stockholder is required to designate a nominee and an alternate nominee sa articles of incorporation. Sinabi ko na kanina yon. The articles will also state the names, residences, and addresses, contact details of the nominee and also alternate nominee, as well as the extent and limitations of the authority in managing the affairs of the one-person corporation. Also included, attached to the articles of incorporation is the written consent of both the nominee and alternate nominee. Remember, kung may consent, obviously it can be withdrawn in writing anytime before the death or incapacity of the single stockholder. So, kailangan ng written consent ng nominee. Pero pwede rin niyang i-withdraw yung kanyang written consent at any time before the death or incapacity of the single stockholder. The term of the nominee in case of temporary incapacity until the single stockholder by self-determination, siyang mag-determine, parang okay na ako. So, mawawala na ng role yung nominee or alternate nominee. By self-determination regains the capacity to assume such duties. So, babalik na sa single stockholder yan. So, yun ang term niya during the temporary incapacity. What else? In case of death or permanent incapacity, nominee will sit as director and manage the affairs until the legal heirs na of the single stockholder shall have been determined. Alam na nila kung sino ang kanyang mga legal heirs, and the heirs have designated one of them to become the one-person corporation, or that the estate will be the single stockholder noong OPC. Remember, ang estate ng namatay can become one-person corporation. Allowed yan. Diba? Natural person, trustee, estate. What else? Alternate nominee will sit as director in case of the nominee's inability, incapacity, death, or refusal to discharge functions as director and manager of the corporation, but under the same rules as the original nominee. So dun lang they will not serve at the same time. The alternate nominee will serve only in case hindi nakapag-serve nag-refuse mag-serve yung original nominee. Nominees can be changed so without need to amend the articles of incorporation. So paano mapapalitan ng nominee? Just submit yung submit to the SEC the names of the new nominees and their corresponding written consent. So, kung pwedeng i-withdraw ng nominee yung consent niya, pwede rin siyang palitan ng single stockholder. Hanap lang siya ng iba, kunin niya yung consent ng mga yon. What else? Minutes book. Under section 127, the minutes book will contain all actions, decisions, and resolution taken by the one-person corporation. So, syempre dahil nag-isa lang siya, alangan namang mag-meeting pa siya, di ba? Alangan. Mag-isa ka nang halag, mag-meeting ka pa. So, medyo natawa ko sa part na yun. So, dahil nga naman hindi na kailangan ng meeting, remember this is an exception doon sa, di ba, usually ang action ng corporation is through the board of directors or trustees acting in a duly constituted meeting. This is one of the exceptions. Hindi na kailangan ng meeting sa one-person corporation. But remember, class, kung merong mga resolutions, kailangan mag-prepare ng written resolution signed and dated by the single stockholder and record the same in the minutes book of the one-person corporation. So the date of recording in the minutes book will be considered as the date of meeting. Yan. Kunwari may meeting. So, reportorial requirements. So, to prevent abuse of power and conflict of interest situations, kailangan mag-submit ng mga following documents. Under 129, annual financial statements audited by an independent certified public accountant. Pero if the total assets or total liabilities are less than 600, yung 1,000 financial statements shall be certified under oath by the corporation's treasurer and president. So kung isa lang yan, edi isa lang magsa-certify. Because remember, your sole stockholder can be director siya, di ba? President can be appointed as can be the self-appointed treasurer as well. Pagka naman independent auditor ang ginamit mo na nag-audit ng financial statements, in case merong adverse remark or disclaimer made by the independent auditor, kailangang mag-submit din ng report containing explanations or comments by the president on every qualification, reservation, or adverse remark or disclaimer made by the auditor dun sa kanyang report. What else? Disclosure of all self-dealings and related party transactions entered into between the one-person corporation and the single stockholder. So, all transactions in a personal capacity must be recorded reported to the SEC and other reports as the SEC may require. So in case of delinquency, remember SEC may place the one person corporation under delinquent status. Kung nagkaroon ng failure to submit reportorial requirements 3 times consecutively or intermittently, sunod-sunod or hindi naman sunod-sunod, minsan meron, minsan wala, within the period of 5 years. Yun naman yung intermittently, minsan meron, minsan wala. Within a period of 5 years, pwedeng i-declare yung one-person corporation as delinquent. So, limited liability of one-person corporation. So, limited to investment. But remember, class, single stockholder has the burden of showing that yung one-person corporation was adequately financed. So, up to the investment lang niya. Ako mag-invest ako sa one-person corporation, yun lang ang liability kung ano yung investment ko. But I have the burden of proving that yung aking business is adequately financed for the benefit of third persons. Now, if I cannot prove na yung mga properties ko is independent of the properties of the one-person corporation, yung single stockholder will be jointly and severally liable, meaning solidarily liable for the debt and other liabilities of the one-person corporation. So, dito na naman pumapasok yung application ng doctrine of piercing the veil. Kasi nga naman, if obviously yung one-person corporation tsaka yung single stockholder, parang hindi naman talaga finand yung one-person corporation or yung properties ng one-person corporation, wala naman talaga. Yung property lang, personal na properties lang talaga ng ng single stockholder. Magkakaroon ng piercing the veil because the same rule applies. So, magkakaroon na ng solidary liability between the one-person corporation and the single stockholder. Bakit? Kasi you cannot prove na magkahiwalay talaga yung properties niyan and that it is sufficient, the one-person corporation is sufficiently funded. What else? Can you convert a one-person corporation to, can you convert an ordinary corporation to a one-person corporation? The answer under section 131 is yes, pwede. So, usually this will happen when one stockholder acquires all the shares of stock in an ordinary corporation. Total, sa akin naman na lahat ng shares of stock, tas mag-isa na lang ako, edi mag-apply na lang ako as, mag-convert na lang ako into a one-person corporation. Because remember, a regular stock corporation, at least 2, yun ang sabi ng law. So, the remaining stockholder must submit such documents as the SEC may require, and the application for conversion will be approved by the SEC by issuing a certificate of filing of amended articles of incorporation reflecting the conversion. So, yung one-person corporation which was originally an ordinary stock corporation shall be legally responsible for the obligation of the original ordinary stock corporation as of the date of conversion. Paano kung baliktad? Can you convert a one-person corporation to an ordinary corporation? Yes, it can happen also according to 132. Pwede naman. How will it happen? Single stockholder ka, OPC ka, tapos somebody decides to invest in your business. Alangan namang tanggihan mo yung kapital na papasok sa business mo. So, if that happens, you can convert your OPC into an ordinary stock corporation. So, notify the SEC of such fact and of the circumstances which leads to the conversion. Comply with all the requirements for stock corporations under sections 14 and 15 and other applicable rules. So, notice to the SEC shall be filed within 60 days from the occurrence of the circumstances leading to conversion. So, 60 days kailangan makapag-file ka na ng notice sa SEC. Now, if all the requirements have been complied with, SEC shall issue a certificate of filing of amended articles of incorporation to reflect the conversion. So, obviously, in both cases, in 131 and 132, there should be an amendment of the articles of incorporation. So, kung ordinary stock corporation ka, you want to incorporate as an OPC, convert to an OPC, kailangan mong isama yung mga additional provisions provided by the title on one-person corporations, like mag-appoint ka ng nominee, tsaka yung alternate nominee, tsaka yung mga consent formula, etc., etc. So, again, yung ordinary stock corporation converted from an OPC shall be liable for all the responsibilities of the OPC as of the date of conversion. So that's it for Title 13, Special Corporations. Please stand by for Title 14. We will talk about dissolution. Anyway, thank you class and have a good night.